Assalamu alaikum and welcome to the Politics and Media Show with me, Salma Yaqub. In a significant victory for campaigners, MPs have called for a review of the UK's extradition treaty with America. After a historic debate, they unanimously passed a motion last week calling on the government to change the law. Critics have long argued the treaty is unfair because it's easier for Britons to be extradited to America than for US citizens to be brought here to face trial. The debate followed an e-petition by the family of Babar Ahmad, which was signed by over 140,000 people, and calls for Ahmad to be tried in the UK. He's been held in prison for the past 7 years, despite not being charged in the UK. The US wants to extradite him to America for alleged terrorism offences, which he denies. Well, before I introduce today's guests, let's take a quick look at some of the background in the extradition treaty.
British Prime Minister David Cameron is facing increasing pressure to shake up extradition rules with the US after Parliament demanded action. In a landmark debate last week, MPs unanimously passed a motion calling for a review of the extradition treaty between the US and UK, which critics argue is unfair. MPs argued that the 2003 extradition treaty is unfairly balanced against Britain because it is harder to bring a suspect from the US here than to send one from the UK. A landmark case in which the issue of extradition has been a focal point is that of Babar Ahmad, who has been in prison for the past 7 years fighting extradition to the US. In his case, like that of several others, he is suspected of being involved in terrorism, but his lawyers are not allowed to see any of the evidence against him because it is secret evidence, nor has he been charged with any crime. It's had rights groups up in arms. So will the Commons debate yield any positive results? Will there be a change in the extradition treaty? And will this affect the case of Babar Ahmad?
With me in the studio to discuss this is Andrew Slaughter, who is a Labour MP and Shadow Justice Minister. Welcome to the show. We're also joined on the line by Alun Jones QC, who's a barrister and a leading expert on extradition law in the UK. Thanks, Alun, for joining us.
Hello, good afternoon.
If I can come to you first, Alun, what legal implications does this debate have, do you think?
Well, there are two major problems. One is that the treaty we have with the United States of America permits the United States authorities to seek extradition on a simple description of conduct, whereas if it's the other way around, we have to provide them with evidence, the adequacy of which the US authorities assess themselves. But the major problem, and I think this is a really serious question affecting our national sovereignty, is that there is no provision in English law to refuse extradition if a person could be tried in this jurisdiction. Now, the Babar Ahmad case is a good example of this, because he is accused of committing acts of terrorism from his home in the United Kingdom and of supporting Chechen and Taliban terrorism, as they allege, between the years 1997 and 2000. Now, the point that I want to make is that I think any developed legal system would think it was right to try him for those allegations in this country. If he's extradited, it'll be very hard for him to call witnesses. His family will find it very difficult to visit him, to get visas, because they will be themselves suspected of associating with terrorists. If he's convicted, he's likely to get life imprisonment without parole. He's likely to get sentenced to imprisonment in a supermax prison where the conditions are truly alarming, and he will also be faced with very considerable pressure to plead guilty to get a lower term of imprisonment than the decades or life imprisonment which he's likely to get if he's convicted. So what we should do is introduce some simple system so that if a person is accused of crime committed in this country by the United States of America, if the interests of justice require it, we should try the person here and not automatically extradite him at the request of a government who doesn't even have to provide any evidence to justify the request for extradition.
Well, thank you for that summary there. And if I could turn to you, Andrew, why has it taken this long for this issue to be debated? I mean, the issues there seem pretty straightforward in one sense.
Well, I think Alun has crystallised the two key issues. There are other issues around the whole extradition debate, and indeed this was, although it came out of the Babar Ahmad petition, and all credit to the work that's been done in raising those 140,000 signatures, because that's what I think got not just one but two debates in the last 2 weeks.
That's pretty remarkable.
That is remarkable, and I took part in the first of those debates. And there are many other cases as well. There's the case of Tala Hassan, which is also a British citizen from Tooting, Sadiq Khan's constituency, who's similarly been in prison. But there are many cases.
And there's Gary McKinnon, of course.
Gary McKinnon. The defining case with Babar Ahmad and Tala Hassan is that they are in custody. And have been in custody for long periods of time without any evidence being presented to British court. And you're right to say, therefore, that this has gone on for a long time. Even people who were responsible for introducing the original laws are now saying that there have been unintended consequences. And I noticed there was an article in the Sunday Times. I'm not privy to what the government is intending to do on this, but the fact that the government didn't, in the end, oppose the Commons debate, as the briefing in advance was that the government was going to try and defeat the motion. They didn't. They allowed it to go through unanimously.
So that's quite significant.
That is significant, and that what looked like a leak in the Sunday Times on the weekend said that they were now prepared to concede on those 2 points, and indeed that the Americans were now saying it wasn't a problem, which makes you wonder why it has been a problem for the past. So it looks like we will make progress. The remaining point that's of concern to me, apart from actually getting that from the government officially and a timetable for it, is whether it will apply to existing cases, so whether it will actually apply to cases like Babar Ahmad, because without going into the merits of the case, and of course in a way we can't because no evidence has been presented in the UK.
Of course the whole issue hasn't been about whether he's innocent or guilty, it's about the right to have a trial in the UK.
It's exactly, as Alun Jones said, it's about the fact that there is no need to present evidence for an extradition one way going to the US, but it is the other way. But also this issue, it's called forum in the technicality, which is why shouldn't somebody who is alleged to have committed offences, whatever they are, in the UK, be tried in the UK under British law as a British citizen? And
historically, that agreement was presumably agreed by politicians, and it's not a unique situation in one sense, the idea of extradition between countries, but no other country seems to have conceded so much of its own citizens' rights. Why is that the case?
No, and it is I mean, I was giving an interview yesterday about the case of an alleged Albanian war criminal, torturer, who was in the UK, who was given bail, even though they were a foreign national, and who has now absconded and are wanted for very serious crimes of kidnapping and torture. So the whole system appears to be in a mess in that way, and it does need political oversight as well as the judicial oversight which it's getting. I mean, the Babar Ahmad case is progressing through the European Court of Human Rights, and that takes a long time. But in the meantime, he has effectively done the equivalent of a 14-year prison sentence with no evidence being presented in the UK, and that is, that's unprecedented, really.
Alun, if I can come back to you, we just talked about some of the politics there, but another shocking revelation came out just a week or so ago, that the CPS had not even seen the evidence. What does that say about the British legal system?
Oh, that's a very common event. There are extradition requests we get from all over the world, and the Crown Prosecution Service represents foreign governments. And in doing so, it tends to convey the impression that some serious scrutiny has taken place of the request from a foreign jurisdiction. But we get hundreds of extradition requests a year, and the CPS doesn't have the resources or time, manpower, to investigate any of those cases, and it is effectively obliged to take them on trust. I mean, there was a request for extradition from Rwanda 4 years ago, in which 4 men were locked up in Belmarsh prison for 2 years and 3 months on deplorably inadequate and suspect evidence. And the Crown Prosecution Service conducted virtually no tests on that evidence at all before the case eventually collapsed, and the 4 men were released with their reputations ruined after great expense, and nobody, of course, derives any satisfaction from the result, neither the Rwandan government, nor the CPS, nor the people who've been locked up in prison. And I feel there's a tremendous temptation for the CPS to export justice by complying with extradition requests rather than to undertake the expense of investigating the case and, if necessary, prosecuting it in this jurisdiction. After all, if another country, such as America, wants to prosecute the case, it's cheaper for us to conduct extradition proceedings normally than it is to conduct the investigation and prosecution here. But the other point I want to make is that the present arrangements were all passed in the Extradition Act 2003. And there was a tremendous desire in the Labour government of that time, supported, it has to be said, by the Conservative opposition, to make us look as though we were in what Jack Straw called the vanguard of change in extradition law. And our government set out to be the most radical and obliging jurisdiction in extradition law in Europe in an attempt to show the rest of the world a lead. And all this was bound up with enthusiasm for the European framework decision of the European Union, and also the war against terror. So extradition became a very political type subject in 2003. And all the difficulties we've seen since with Babar Ahmad's case and so many others derive from this willingness of the United Kingdom government to export some of its legal problems and to try to be in the vanguard of change. And that's why we're in this difficulty.
What's your response that it was our zealousness in the war on terror and being seen to be as close to America as possible that's brought about this?
Well, again, Alan's right that there are issues that aren't just in relation to America, but in relation to European countries as well, which have been highlighted by MPs of all parties. And there does seem to be now consensus, even amongst some of those who were responsible for the original legislation. David Blunkett made an interesting speech in the Commons last week saying that we do need to look at this again. And now some people might say these were predictable consequences.
Yeah.
Some will say that they were unintended consequences.
Well, and some people said
it.
that they predicted them there and then. It wasn't that this hindsight is now allowing the light to be shone on these issues. Because
some of the jurisdictions which we're operating with, which would seem at face value to have a justice system which is equivalent in its safeguards to that of the UK, in practice have not, and there have been some horror stories. I hope there is now that consensus that we need to look at again, in particular the two areas that we've talked about, of prima facie evidence and of forum, i.e. What is the appropriate place to try, because clearly things have gone too far down that route. I mean, extradition has to happen. And it can be very frustrating when known criminals are operating freely in other countries. I mean, I also deal, for example, I have a lot of requests from the Egyptian community in my constituents and other Arab communities about people who have fled in the Arab Spring from Arab countries to the UK, either as criminals with a violent background or extortion from those countries, and who are effectively living at large in London.
But most of our viewers would be sympathetic.
Indeed.
In those cases.
So
the issue here is a crime was supposed to be committed in England.
In the end, it is a balance, because you have to be responsible for international justice. I used the example of the Albanian a few moments ago. You have to get the balance right. I think there is now an agreement. I hope there's an agreement across the parties. In the end, it's for the government to determine this at the moment, that we have gone too far in this and we need to address the balance.
Yes, that's absolutely right. Extradition should be about returning fugitives to the country where they committed the crime and from which they fled. And extradition does happen in those circumstances, but in addition, it's now being used to extradite countries who take a more muscular and vigorous approach than we do to people who are alleged to have committed crimes, but in fact are living in our country.
Yes, and the forum test, the test which says if a crime has been committed, and this is what the Babar Ahmad petition said. It did not say release Babar Ahmad. It said try Babar Ahmad in the UK if you have the evidence to do that. So I think that phrasing in those terms has put pressure on the government.
And Andrew, another point to bear in mind is that we have all the necessary procedures by which we can try people like Babar Ahmad in this country. We have mutual legal assistance treaties with the United States, with countries in Europe, which permit us to request the provision of evidence from those countries. So they can send documents from the United States to England. They can send witnesses. There have been witnesses, even witnesses serving in prison, who've been flown over to the Old Bailey to give evidence in cases. Video links are possible. And if extradition is founded upon trust between equal partners, countries like the United States and our partners in Europe cannot possibly object if we want to try people like Babar Ahmad in this country. And if we request the evidence, they should provide it with good grace, as the treaties between us envisage.
Do you think in this case perhaps there was a feeling that the United States would get offended if their request was not met, and Babar Ahmad in a way has been in prison all this time because people are scared of that offence rather than looking at the facts of the case itself?
Undoubtedly that's true. And one of my concerns is that anybody looking at these cases dispassionately in 2004 to 2006, and it's that time since Babar Ahmad has been remanded in prison, anybody who asks himself the question, where will Babar Ahmad most quickly be tried? The answer would have been in the United Kingdom. He would have been tried and either acquitted or convicted by 2006. And the reason is because people will fight as hard as they can to avoid extradition to the United States of America, where the pressures are, as I described them earlier, and some of the conditions quite unacceptable. They will fight as hard as they can. Everybody knows that when someone appeals to the European Court of Human Rights, that court is likely to take seriously their complaints about extradition to the United States of America, and there will be years of delay before the matter is resolved. So when Babar Ahmad was arrested, the Director of Public Prosecutions ought to have realised that if he wants a proper, early and thorough trial, it will take place it would have taken place years sooner in the United Kingdom than after long years of legal process and an extradition.
But my understanding is that the DPP in the UK has never expressed an intention so far of wishing to try it, of saying that as far as the British authorities
they said they had insufficient evidence.
Insufficient evidence. When I spoke about this in the House of Commons, I said the situation with Babar Ahmad was Kafkaesque, meaning that he was being imprisoned without knowing the case against him. Actually, afterwards, I thought it's worse than that. He's being imprisoned without the people who've imprisoned him knowing the case against him.
But the DPP, Andrew, could have requested the evidence from the United States. He could have said, this person is living in this country, you say there's a case against him, and you accuse him of committing a crime in London to the prejudice of people in the United States and elsewhere. Let me see the evidence, so I can make an informed decision as to whether to prosecute him here.
Well, it's a nightmare situation, and it
could
exactly happen to anybody, and it seems that what recourse has there been? I mean, it's been quite fortunate now with the 140,000 petition, and it's remarkable that we've had these two debates and now there's public awareness, but it's taken 7 long years to get here, and of course he's still in prison. It
has, and I don't think without the petition and without all the efforts that the community have gone to raise that petition, and then the debates with cross-party support across Commons, and the pressure that was put on the government, that we would have got as far as we have. If, as I said, if the reports that are now in the press suggest that the government is going to make those concessions now and presumably do that quickly, then that's obviously good. But it's been achieved in the face of the legal establishment, if you will, a political establishment, rather than them coming to their own conclusion.
So before I ask you what you think the next steps would be, would you think there's actually the silver lining to this tragic case, in that whilst it's highlighted how the system can fail and fail with very tragic consequences, actually there's a system there which people have followed, there's a democracy, this many people protesting about it, calling their MPs up, making sure the debate happened, actually ensured that debate happened, and now we have a cross-party consensus.
Absolutely. Actually, I was slightly annoyed that we weren't having a debate just about Babar Ahmad, because that's what the petition was, and there have been petitions that have got a lot fewer signatures than 140,000, which have been debated on the floor of the House, and we had to make a big fuss to move the debate initially from a side chamber into the main chamber. But actually, I think it worked well in the end, because it highlighted a whole number of cases, and therefore it got a much broader level of support from different constituency MPs, different parties and so forth. And a lot of people have put an effort into this now. We're not there yet, let me just say that. Let's not get overexcited about it. There's a lot of work still to be done. And of course we do have to always still bear in mind that we have to have an extradition process that works. But at least it is now in the forefront of the government's mind.
And of course the cases we're talking about are not just allegations of terrorism. Fraud cases, for example, present exactly the same problem. And the great example of that was the so-called NatWest 3, David Birmingham and two other people. They were employees of National Westminster Bank in London. They had a business in the United States of America and were accused by prosecutors in Texas of conspiring to defraud their own employer, National Westminster Bank, in London. Now, they were accused because the three of them did have some dealings with people who were suspected of the Enron fraud. And the American prosecutors hoped that by starting a prosecution against the NatWest 3, they would rapidly go to the United States of America, do a plea bargain, plead guilty, and give evidence against people in Enron. But that didn't happen because they denied the offence. They were accused in America simply because they had had some limited email traffic with people in the United States of America at the appropriate time. Now, National Westminster Bank never accused them of fraud. They never said they had been defrauded. And yet, because there'd been this email traffic, the American courts claimed jurisdiction over the alleged fraud and applied for their extradition. Now, that should never have happened. That case should have been looked at in this jurisdiction. It was looked at. Nobody ever brought any prosecution because the bank didn't claim to have been defrauded. But in the end, pursuant to this absurd treaty, they were extradited.
So just to wrap up, because we're running out of time in the first half, how do you see the next steps? If I can come to you first, Andrew.
Well, we're waiting for the fact that the government did not oppose, have accepted the view of the Commons on this, and this is specifically a backbench, all-party Commons campaign based on the Babar Ahmad petition. They now have to respond, and I hope that, as I say, the signs are that they're going to respond quickly to this, and they're going to accept the recommendations of the Joint Committee on Human Rights, which include both of the provisions which Alan Joe spoke about, i.e. there has to be evidence, and if it is more appropriate, then it has to be tried in the UK. So I'm hoping we will get an announcement on that fairly soon. I'm then hoping that we will hear news of how that fits existing cases, and it will be outrageous, given that the whole campaign is built on cases like Babar Ahmad and Gary McKinnon, if they are excluded from whatever policy is then introduced.
And the final word to you, Alan?
Yes, I agree, and it's a tribute to the various members of Parliament who have brought this debate to full parliamentary attention and put sufficient pressure upon the government to make it look as though they're prepared to change their minds. It is a victory for democracy.
Well, we're watching history in motion there. Do stay with us for part 2.